So my name is Sash Silvera. I am presenting with you on behalf of the Coalition to Protect Kids New York. We are a nonpartisan committee of New Yorkers, just like all of you, that learned about the Equal Rights Amendment that is slated to appear on our ballots in November. Our state legislature is seeking to amend our state constitution. They want to enshrine 12 new protected classes to our already existing Equal Rights Amendment that exists, that already guarantees equal protections to all New Yorkers. So the Coalition to Protect Kids, can this come out? The Coalition to Protect Kids, we are a ballot issue committee, so we are registered with the New York State Board of Elections, comprised, like I said, of New Yorkers from all walks of life, nonpartisan, so we do not endorse or condemn candidates. This is a ballot issue public awareness campaign. We want every New Yorker in every crevice of the state to be fully aware and not be surprised or blinded or deceived when they read Proposition 1 on the back of their ballots in November. We've dubbed this Equal Rights Amendment as the Parent Replacement Act because essentially that's what the state seeks to do, replace our voice with theirs, our values with theirs. Next. So the Equal Right Amendment, you'll hear people talk about this. Some people are calling it the Equal Rights Amendment. Now that we know it's going to be the first proposition on the ballot, you may hear people just say Prop 1 or Proposition 1. Some people are calling it the Equality Act. You might hear people calling it the Parent Replacement Act. It's the same thing. So what happens is New York is looking to amend our state constitution to say unequivocally that laws and entities cannot discriminate on the basis of new categories such as age, gender identity, gender expression, gender orientation, reproductive health care and autonomy. Health care and autonomy, that's language, what it means is abortion rights. The amendment is up for a statewide popular vote on this year's general election ballot on November 5th. There is an update to this. The way that our Constitution is able to be amended, the Constitution actually tells you what you have to do. Our legislature didn't do what they were supposed to do. So unconstitutionally, they got this proposition on the ballot. It's supposed to be voted on in 2 consecutive legislative sessions. But in between, it's supposed to go for an attorney general's opinion. In 2022, that did not occur. So they voted twice, passed it in the same day, both houses, and that's unconstitutional. So, yeah, the Senate and Assembly, yeah. So it's supposed to go for an attorney general's opinion. So the vote happened in the session in 2022 and 2023, but they missed a step in 2022 to get it on this presidential ballot because the presidential election just brings out many more people to vote than local elections. So in that respect, you'd get a lot more blind voters to see equal rights and think that that's a great thing without understanding the ramifications and what really is baked into that. So an assemblywoman from West New York brought a suit and said, hey, the legislature is being unconstitutional. They did not follow the guidelines of the Constitution. This proposition should not be on the ballot because they didn't do it the right way. It was argued and ruled on 2 weeks ago, May 7th. The judge said, you're right. He ruled in favor of the people. He said they did not follow the Constitution. Kick this thing back to the legislature and let them do it the right way. So it's technically off the ballot. However, good old Letitia James filed her appeal last Tuesday. So it'll be heard on appeal, which is their right in the appellate court, and things sometimes get compromised in our court system. So we are moving forward as if, because it could very well be on the ballot in November if things aren't done lawfully on the appeal side. So just letting you know, technically, it's off right now. However, we do believe it will be back on. We do think the courts are compromised, and we just don't know what's going to happen. So we just want to continue to raise the awareness. If it doesn't make it, it will be back, just another ballot, and we can shift our focus and pressure back to the legislature, because when this happened in 22 and 23, we didn't know. It was in the dark. Now we're aware. So it won't be such a secret or a surprise. Now we can, if the appellate division does rule in the correct way constitutionally, we can put the pressure on the legislature. Otherwise, we need to keep the public fully aware so that they're not misled when they see the language.
Sash, didn't Kathy Hochul say she's going to support the appeal also?
She does, yeah.
Yeah, so
yeah. She does.
We need to be praying about that.
Letitia James works for her. Yeah. she the day that the judge ruled, they vowed that they were going to appeal and get it back. And I want to get on with the presentation, but back to our civics education, what they said in a lot of the media publishing that were written up about their feedback about the judge taking it off the ballot, they said, hey, we've gotten amendments changed in the state of New York over the last 50 years by the same pathway, meaning we violated the Constitution 13 times in the last 50 years. So why are you stopping us now, basically? Imagine that. So what you're looking at is the proposed changes that are in boldface. The regular font is what our Constitution says now. What's bolded are what they're proposing to add. This is not the language that you'll see likely on the ballot, should it appear on the ballot, because we don't have that information yet. They'll probably paraphrase it and make it sound nice and fluffy. But so right now, as it stands, our Constitution's Equal Protection Clause states that no person shall, because of race, color, creed, or religion, be subjected to any discrimination in his or her civil rights by any other person or any firm, corporation, or institution, or by the state or any agency or subdivision of the state. Now they want to add 12 additional protected classes, which are ethnicity, national origin, age, disability, sex. Sex is being defined as including sexual orientation, gender identity, gender expression, pregnancy outcomes, and reproductive health care and autonomy. And then if you'll notice, Section B, that's all completely new language. This is the real hook right here. Nothing in this section shall invalidate or prevent the adoption of any law, regulation, program, or practice that is designed to prevent or dismantle discrimination on the basis of a characteristic listed in this section. Nor shall any characteristic listed in this section be interpreted to interfere with, limit, or deny the civil rights of any person based upon any other characteristic identified in this section. So it took us a lot of mulling over to figure out what were they trying to say in all of these words. And they're permitting basically discrimination in their clause to prevent discrimination, because if you're going to say that nothing shall invalidate the adoption of any law, regulation, program, or practice is basically what they're doing in our schools right now, the things that they're exposing our kids to, the way that they're determining whether they're going to involve parents in these decisions or keep parents in the dark. Those are practices. Those are not laws. But this proposed change is basically saying something like that could not be dismantled if it discriminated against one of these protected classes. So I'll show you examples. It's a little clunky, but I'll show you some examples, some real life examples in a little bit. But that part B is very troubling because it's giving them very broad, vague, uninterrupted abilities to do whatever they want, because now anything could be determined or framed as discriminatory. So the ERA is composed in dramatically vague, one-size-fits-all language. If this is passed, it could open up the proverbial Pandora's box of issues that negatively impact parental rights in children. That's the language of our existing Equal Rights Amendment, which I read to you before, guarantees protections for everyone. So we'll take a few minutes and look at some of the key takeaways and what it means to be able to discriminate. We discriminate. We don't call it that. Like, parents train up their kids in the way they should go. We guide, we control, we direct, we protect our minor children. We do discriminate. We don't let our minor children do things that 21-year-olds are doing. We do not let our 5-year-olds do that. Elders, seniors, we discriminate. We don't call it that. We call it protections or, guidelines for maybe senior housing programs, different discounts and different things of that sort. We do, it's just not wide open. We do protect on a more distinguished basis. So a lot of what's proposed in the Equal Rights Amendment, the proponents speak of it as if it were just about women's rights and lasting abortion rights, as if New York does not already have lasting abortion rights. New York's abortion rights are codified into law for probably over 60, 70 years now. So it's a deception to mislead that group that thinks they're losing their rights to abortion because of Roe versus Wade, which is not true. What it is taking away the attention from everything else that the Equal Rights Amendment represents. So they're focused on their abortions, but they're going to give up their parental rights in one fell swoop. Key takeaways: the New York State government could have more authority than parents in making medical and other important decisions for children. Children under the age of 18 could have the right to irreversible surgical and non-surgical transgender procedures without parental notice or approval. If you don't discriminate based on age, that means if you try to prevent a 12-year-old from doing something, it could be discrimination. Age requirements for things such as voting, purchasing, and consuming alcohol, senior housing, senior discounts could be legally challenged and deemed unconstitutional. So a 35-year-old can say, that's discrimination. I want the same programs that's available to the 72-year-old. You're discriminating against me. Statutory rape laws that protect against sex with minors or enhanced penalties for attacks against those over 65 could be significantly weakened. Any policy requiring parental notice or consent for children under 18 to undergo an abortion could be deemed unconstitutional. Also, the amendment could legalize on-demand, late-term abortion or abortion without restrictions during the second and third trimester of pregnancy, including for minors. Schools could be banned from disclosing to parents that their children are becoming transgender. Biological males could be allowed to compete against biological females in school sports without restrictions. Protections for churches and other religious institutions could be eroded regarding the teaching of beliefs that run contrary to these newly created rights in the ERA. New York, right? We're always proud to be from New York. Why? Because New York is cultural and legislative leaders in this country and probably the world. What happens here impacts the rest of the nation. The other concern is that there is such a lack of credible research regarding the effects of gender-affirming procedures on minors that the benefits of parental notice and the consent on the health status of their children are of serious concern. So this is kind of restating. These are questions. It sounds rhetorical, but it's really not. If this amendment were to pass, should minors have the right to irreversible surgical and non-surgical transgender procedures without parental notice or consent? This can include anything from puberty blocking hormones, gender reassignment surgeries, hormone replacement therapies without parental knowledge or consent. Should we allow minors to purchase and/or consume alcohol and cannabis? Should we do away with senior housing altogether and any discounts that are dedicated to seniors? Should statutory rape laws that protect against sex with minors be reduced? And should the voice of the church and other religious institutions be stifled? Should children under 18 have unrestricted access to abortion and without parental notice or consent? Should schools be banned from disclosing to parents that their children are seeking to transition their genders? These, again, you're probably sitting here saying, well, Sash, this is already happening. We already have biological males playing sports against biological females. The school's already doing things without parental consent and undermining parents. This stuff is happening. It really is already. Why we don't want it enshrined in our Constitution is because currently we have standing. We can go to courts, the judiciary, and we can fight for our constitutional protections to be acknowledged and that they were undermined and violated. If our Constitution is amended and takes away that from us and enshrines these protections for minor children in these new categories of sexes, the courts are bound to uphold the Constitution. They are constitutionally protected. This is a problem. This is a direct conflict with parental rights to direct and protect their kids, and essentially giving minors rights to make their own decisions in their immature, undeveloped mentalities, and they were blessed with parents to guide them and protect them. The consequences are grave. The New York State Constitution, again, the Constitution is not just, it is, but not just a historical document. I think a lot of people just think it's some old school historical document. It is supreme law, the supreme law of this land. It supersedes any and all state laws, statutes, and regulations. If these poorly written, one-size-fits-all additions to the amendment pass, each of the common sense guardrails that protect kids could be deemed unconstitutional under the New York State Constitution. I'm a parent, I'm a native New Yorker. This concerns me deeply. I've gone to so many of our legislators that supported this and that opposed it and asked them why. Help me understand, what is it that you support about this? I support equal rights for everybody. I'm not stupid, I could read. Let's go deeper. What about this is equal rights? I support equal rights for everybody. The opposition, they don't feel abortion should be enshrined in the Constitution. That's not the purpose of a Constitution. They don't believe that parental rights should be usurped by the government. That's not the government's role or place. And they don't believe that minors should be endangered in the way that they are with these new constitutional protections. So the next question I asked them both, well, what's going to happen? Because there's going to be an inevitable conflict, right? Children are going to be doing things that are going to be dangerous and harmful. Parents are going to be fighting to protect their kids. So what's up? What's going to happen? The courts will decide. The courts will ultimately have to determine the outcome and interpret. So this is what our legislatures, this is where they want to dump our family in the court. So it's really concerning because there is no answer. I asked, where's the safeguards for minor children and parental rights? The courts will decide if there's a conflict. And I think we deserve a lot better than that. And mind you, they've been working on this Equal Rights Amendment for at least 10 years. A long time they've been working on this, and this is what they've come up with. So it's pretty horrendous. I'm going to show you next just a couple of things, because some people think I'm fear-mongering when I deliver this information. They would never do that. Oh, our government would never do that. These are just, aside from the ERA legislation that they want on our ballot in November, these are some active bills that are currently sitting in our legislature. You know, the legislative session is on right now, probably through the first week of June, so they are voting on bills all day, every day. These are what have been proposed by some of our legislators, sponsored, and they're seeking to advance. So A6761, Assembly Bill, this one seeks to allow minors to make their own medical decisions without parental knowledge or consent. So this includes anything from dental procedures, medical interventions, vaccines, surgeries, hospitalizations, psychotropic drugs, you name it. If the doctor deems your child, and there's no low age threshold, so it's like a 5-year-old, a 9-year-old, a 17-year-old, yes. If the doctor determines, after spending a whole whopping 15 minutes with your child, that they're mature enough and understand the risk and benefits to make this decision, they determine the maturity of your child to do something like this. There was a companion Senate bill to that. That senator, I mean, there's been a lot of outrage, rallies, all kind of commotion over this because it's horrendous. The senator that proposed the Senate bill up to this, she just withdrew the bill last week, so that's a good thing. But the Assembly bill is still standing. It needs a companion bill to advance, so it may not advance in this session, but somebody's proposed it, and a lot of our legislators sponsored it. So somebody wants this. Maybe it's the medical industrial complex. I don't know who would want something like this. Assembly Bill A276B, another one that's been advancing in our legislature. This one seeks to allow minors to get sexually transmitted STD testing and treatment. Vaccines, you name it, whatever monkeypox, everything now is an STD, so it keeps growing, the list keeps growing, but this would allow minors without parental or guardian knowledge or consent to make these decisions. This is extremely troubling when you think of the way children are being abused, harmed, trafficked. If their abuser were to harm them, they could essentially help them get themselves taken care of without the parents even knowing, and the doctor is not even saying a parent should be aware that their child is being evaluated for such things. So that's extremely troubling, like everything else. A4604 is another one. This one is seeking to require comprehensive sexuality education in all public schools for students in grades K through 12. So K is like 5 years old, right? 5 years old. And required, meaning parents cannot opt their child out of this. This would be a required program if this were to pass. So these are just some dots to connect. When you think about them proposing to amend our Constitution, and then you look at some of the laws that they're proposing and supporting, it makes you wonder what's really going on here. And NYSED, the New York State Ed Department. So last June 2023, NYSED sent out this document to all schools It's called Creating a Safe, Supportive, and Affirming School Environment for Transgender and Gender Expansive Students. They called it a legal update and best practices. So that's kind of like a conundrum. Is it legal or is it a best practice? Like it's one or the other. Because legal sounds threatening, like there's some legal punishment if you don't do this. And best practices seems like we recommend this, we suggest this. So when this goes out to your school districts and you don't have discerning superintendents or administrators, they just kind of willfully comply and do what they're directed to do, even though they don't have to. This is not a law, but when you think back to the Part B in the proposed changes, programs, practices, this is a practice. Now, if that amendment were to pass and you challenge this, it would be unconstitutional because you can't just try to dismantle a practice that would discriminate against a protected class, which would be someone who identifies as transgender or transgender expansive. So this is going on in the schools. The state education department sent this out over almost a year ago. It's in practice. Most parents have no clue. I'll show you just a couple of quotes that I lifted directly from the document. It's a 42-page document. You could Google it and read it. It's outrageous, but it says, quote, students are not required to obtain parental or guardian consent or a court-ordered name or gender change before being addressed by their affirmed name and pronouns. Quote, the student is in charge of their gender transition and the school's role is to provide support. Quote, some TGE, transgender, gender expansive students have not talked to their families about their gender identity because of safety concerns or lack of acceptance and may begin their transition at school without parent or guardian knowledge. The school will sit with your child. They have what's called like a gender transition plan. They will sit with your minor child, whether you're there or not. The child decides. The child that you're responsible for will tell the school, no, I don't think I want you to involve my parents in this, and the school finds that acceptable. And this is what they're doing. So this is the exposure part of what we talked about earlier. Exposure. This stuff has to be exposed because you can't question, you can't challenge, you can't seek, more information if you're not even exposed to the fact that these things are happening in our society as it stands. So if that amendment were to pass, challenging anything like this could be deemed unconstitutional. And this is information on registering to vote. So this is going to be, if it gets appealed and they win on the appeal, it will be on the ballot, Proposition 1. You have to be registered to vote. Even if you're not interested in voting for any of the candidates, you have to be registered to vote to be able to vote no, which is what we want to do to this Equal Rights Amendment. So the deadline to register to vote is October 26th. You can do so online at newyork.gov or at your local Board of Elections agency. And election day is November 5th from 6 to 9. And that's really it. And if any of you feel so compelled to join us in this mission and want to take action, we're all volunteers, and we are dedicated to defeating this Equal Rights Amendment. We do not want this to pass. The way we're going about it is public awareness, just to raise awareness, educate the public so that, one, they know what it is, because so many people don't even know what it is, and two, that they don't think it's a great thing without understanding all of the components of it. It's like a real casserole. So we are Protect Kids New York, our website, protectkidsny.com. I encourage you to sign up just to get information because we're sending out updates. Of course, we want to keep a close eye on what happens with this technicality lawsuit, but in general. And if you're interested in doing what I do or something else, we're always seeking support all over New York. Even if you have a cousin up in Rochester or out in Long Island, we need people all over New York delivering this message so that people are informed. You can donate if you don't have time. All of this you can do via the website. And if you do want to support in any capacity, you could also do that on the website as well. At the very least, tell everyone you know about the destructive impacts of the Equal Rights Amendment. We call it the Parent Replacement Act, but it does a lot more. I mean, you think about the church, stifling the church. If your faith and your religious belief, sincerely held religious belief, does not align with these new protected classes, you could be probably sued for discriminating. I know so many churches that would probably just end up closing because of the cost of a lawsuit, you know? So these are serious implications. So protectkidsny.com, tell everyone you know, and we will, like I said, be keeping a close eye on the lawsuit, and should it really pick up steam and come back to us, we're not stopping this messaging. And if it gets ruled the right way, and the second court says, nope, it is unconstitutional, you didn't do what you were supposed to do, now we have to change our approach and really lean in on our legislators that think that this is what we want, because they represent us. And I don't think we voted for any of this. I didn't. Did you?